Hello everybody, and thank you for joining us at Chaucer Digital's GDPR webinar. This afternoon we have Paul Gillingwater, who's going to do some GDPR myth busting for you and take any questions, and also Rob D'Souza, who's going to talk to you about the UK Data Protection Bill as opposed to GDPR or compared to GDPR, so that we can get a bit of a feel for what we need to be doing now and implications post-Brexit. He's also going to then talk to you in a bit of detail about Article 30, which is the one that's very important if anybody's hovering on that edge of 250 employees and wondering about their compliance and if they need to be compliant. The gentlemen will both take questions at the end of the session as well. We hope you enjoy. Over to you, Paul.
Welcome to this webinar on GDPR myths and the Data Protection Bill. Let's start by looking at some of the data protection myths which you find in the marketplace.
The first myth that Paul is going to tackle for us is my company has fewer than 250 employees, so I don't need to comply with GDPR.
There is indeed a reduction in your obligations if you have fewer than 250 employees, but only in terms of documenting your Article 30 data processing activities. Specifically, there are three categories where you have to check if you have an obligation. Those are, number one, if the data processing is likely to result in a risk to the rights and freedoms of data subjects, or the processing is not occasional, or the processing includes special categories of data. So if any of those three are true, you still need to document your data processing activities. But if all of them are not true, so for example, an occasional newsletter is being processed, which doesn't require you to process sensitive information, then that would not need to be documented under Article 30 if you have fewer than 250 employees.
Myth number 2. I'm a sole trader and I keep a list of email addresses for my customers. I also have a couple of CCTV cameras outside of my office which record part of the street. GDPR isn't an issue for me.
Sole traders aren't really exempted from the obligations of GDPR unless the data that's being processed is exclusively personal or household activity data. Now, that also includes closed-circuit TV cameras, but if you have a CCTV camera, it can't be pointing at a public area. It needs to be pointing at your house or apartment in order to qualify for this exemption. But if you're just doing business and you're charging customers for any goods or services, even if you're a sole trader, then GDPR still applies.
Our third myth. GDPR will cause big problems for UK businesses due to its massive fines.
GDPR shouldn't be causing big problems in the UK because fines are not the primary enforcement mechanism, according to the Information Commissioner Elizabeth Denham. She said that her priority is privacy law enforcement through education and advice. It's only if there are going to be massive violations and advice is not followed, that is, a business hasn't bothered to address compliance at all, that fines are likely to be brought into play. And even then, the chances are that you won't be subjected to a fine. In the 2016-2017 reporting year, there were 17,300 cases investigated by the Information Commissioner's Office. Only 16 of those resulted in fines, which is a rate of less than 0.1%. However, since then, the Information Commissioner's Office has said that they're going to be hiring another 200 staff members, so we can expect that number to increase.
Number 4. You must have consent to process personal data.
This is one of the biggest myths that's around there, that you have to have consent to process personal data. In fact, consent is just one of 6 different legal bases. If you don't have clear consent for any legacy data, if consent is chosen, then you do have to stop processing it, or you have to request fresh consent. Note that consent has to be managed, which means it can be withdrawn from at any time by the data subject. so you need to have a business process to handle that. There are 5 other legal bases for the processing of data, including contract fulfillment, legitimate interest, regulatory obligation, and vital interest.
Myth 5. Every business has to hire a DPO. That's a data protection officer.
No, Lindsay, every business doesn't have to hire a DPO. A DPO is required if you're a local authority or other administrative entity that's operating in the public interest. It's also required if you're doing large-scale systematic monitoring of personal data of natural persons. And it's additionally required if you're doing large-scale processing of special personal data. So most businesses will not be obliged to maintain a DPO. However, if the main base of activities of that business is outside the EU, then they may be obliged to appoint an EU-based GDPR representative. One of the good things about having a DPO, if you need one, is that you can outsource that to a suitably qualified individual or business, but you still have to manage your compliance yourself. The DPO doesn't do the job of complying. The DPO acts as an independent advisor and helps the data controllers to maintain their data protection compliance. Chaucer Consulting offers DPO as a service to its customers. Now, if you do appoint a DPO and you're not sure that you absolutely need one, you have to fulfill all of the obligations and duties of having a DPO. So be careful about appointing one if you don't absolutely strictly need one. Note also that one of the DPO obligations is independence, which means that you can't simply say that your CIO or boss of IT is now your DPO. That won't wash with the data processing authorities.
Myth 6. GDPR is the only law I need to worry about.
GDPR, because it's a regulation, will go into effect on May the 25th in all 28 European countries. However, in the UK, there's a draft data protection bill which is currently being reviewed by the House of Lords, and that will become the Data Protection Act of 2018, probably by the end of April. That bill makes a number of changes or derogations to the GDPR. For example, it changes the age of consent for the processing of personal data for children from 16 years to 13 years. Additionally, it adds certain criminal offences or reportable offences into GDPR, which aren't in the underlying regulation. So normally you'd have to read those 2 laws in parallel in order to be fully compliant. Additionally, there's another regulation called the Electronic Privacy Regulation, or EPR. That's also scheduled for May the 25th. However, some people believe that that is less likely to be enacted on time. However, it is on the way. Additionally, you've got the Network and Information Security Directive and the Trade Secrets Directive, some of which may apply but not to all businesses.
Number 7. Every single breach of personal data has to be reported.
Breaches of personal data only need to be reported if they could lead to a significant risk to the rights and privileges of natural persons within the EU. But if the risk is low, you don't need to report it. For instance, if there was a loss or unauthorized change to a staff telephone list, well, that's a data breach, but it's not reportable because it's got a very low risk. On the other hand, if a customer database was stolen and that database contained special classes of identifying information, such as credit card details, date of birth, address, and so on, that could expose the data subjects to the risk of identity theft, meaning that that is a reportable data breach. Whatever choice is made, the rationale for reporting or not reporting has to be documented for later review by the Information Commissioner's Office. A data processor who detects a breach only is obliged to report that event to the data controller. It's the data controller who has the obligation to report to the Information Commissioner's Office and, in some cases, to notify those who are affected by the data breach. Remember, that notification is only required if there's a significant risk to the rights and freedoms. Incidentally, there is an obligation under a separate law for a 24-hour reporting period for communication service providers. That will be further covered by the NIS directive. Failure to report or notify on a reportable breach means that you face fines of up to 10 million euros or up to 2% of the global annual turnover, and that can be combined with other corrective powers. There are 3 exceptions to mandatory breach reporting. Number 1, if you've mitigated the impact of the breach, for example, you encrypted some data before it was breached and the hackers only got the encrypted data, then the risk is minor, so that doesn't have to be reported. Secondly, if you've got a highly effective incident response that reduces the impact, then additionally you're relieved of the duty of reporting your breach. Thirdly, if there is a disproportionate effort required to notify all of the persons affected, then you can avoid reporting the breach. But the barrier for that is quite high, so be careful and take advice.
Myth 8. Data portability right applies to all businesses.
Data portability only applies if you either have consent or contractual fulfillment as your legal basis for processing. It's not an obligation to provide the right of portability if the legal basis is legitimate interests, but you do need to have a documented legitimate interests assessment to show that that is indeed the case.
Consent is required for all profiling activities.
No, consent is not required for all of the profiling activities. If that was the case, most of the marketing companies would be going out of business very quickly. Consent is needed only if the processing activity has either legal effects or the chance of significantly affecting the data subject and her rights. The exemptions to the right to withdraw themselves from automated decision-making include its necessity for entry into or performance of a contract between the data controller and the data subject, or is authorized by the EU or national laws with their own safeguards.
Our 10th myth. If processing children's data, you must obtain parental consent.
You might think that in order to process the data of children, you must obtain parental consent. Well, while that's true in most cases, it's not the case when the processing is based on legitimate interest. In that case, parental consent of minors is not required to process their personal data, but there are additional safeguards that you need. An example of this is if you need to process children's personal data in the context of preventive or counseling services which are offered directly to the child.
This is quite an important one. Myth 11. GDPR applies only to the personal data of EU citizens.
EU citizens are not the only beneficiaries of GDPR. Well, actually, it's a bit of an amorphous group, but basically every citizen of EU are certainly covered if they're within the boundaries of the European Union or the European Economic Area, the EEA. But additionally, there are permanent residents who are not EU citizens, and their rights and freedoms are also included under GDPR. Furthermore, there's some suggestion that this will also apply to tourists of non-European nationalities who are temporarily visiting the country. That may also include asylum seekers and refugees as well. So basically, everyone who's within the borders of the EEA or EU should be included when you're thinking about the scope of applicability of the GDPR.
Our 12th myth. My business is not allowed to transfer personal data outside of the EU anymore.
The good news is your business is not restricted in its ability to transfer personal data outside of the EU. However, you do have to have the appropriate legal basis in place in order to carry out such processing. Data transfers to third countries, or indeed international organizations, will have certain restrictions. One of those restrictions is that the Information Commissioner's Office maintains a list of countries which are considered to have appropriate and adequate safeguards to and from which data transfers will be permitted. Individuals' rights have to be enforceable, and there have to be effective legal remedies for individuals available following the transfer. Some of the safeguards for data transfers to third countries include legally binding agreements between public authorities or bodies. An example of that is the forthcoming Cloud Act in the US, intended to cover the transfer of personal data for the purposes of investigating serious crime or suspected terrorism. A second mechanism, which is quite popular, is binding corporate rules. A nice example of this is provided by Salesforce.com, who offer addendums to their standard contract that invoke the binding corporate rules, which have been agreed by a number of European data protection authorities. Also provided by the data protection authorities are standard contractual clauses in the form of template transfer clauses, which have been adopted by the Commission. Standard data protection clauses in the forms of template transfer clauses have also been adopted by a supervisory authority and approved by the Commission, can also be used to protect the legal basis for third country transfers. Additionally, compliance with an approved code of conduct, which has to be approved by a supervisory authority. There are also planned some certification mechanisms within GDPR, but as far as I'm aware, they haven't been announced yet.
Myth 13. I can't be held personally liable for a lapse in my company's GDPR processes.
Personal liability is a very interesting factor. And it's true that GDPR doesn't have any relevant articles to introduce personal liability for lapses in data protection. However, the draft UK Data Protection Bill introduces new criminal offences relating to data protection failures and holds company directors, senior managers, and company secretaries potentially personally liable for lapses under their control. The bill uses words relating to consent and/or connivance and/or neglect, meaning that the data protection liability is pretty much the same as the legal tests used in the Health and Safety at Work Act of 1974. Bottom line, if you are a company director or senior member of the company's executive, you can indeed be held personally liable for failures in the data protection of your company.
Myth 14. PII is the same as personal data.
The term PII, which means personally identifiable information, comes from American data protection thinking. It's not the same as personal data under GDPR, which is much broader in its scope. Personal data in GDPR is defined as any information relating to an identified or identifiable natural person. That's someone who can be identified either directly or indirectly by reference to an identifier. It could be a name, an identification number, location data, online identifier such as an IP address or email address, or other factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So remember, that can even include cookies, IP addresses, and RFID tags.
Myth 15. When a reportable breach occurs, you only have 72 hours to report it to your lead DPA.
It's usually thought that you have 72 hours after a breach occurs to report it to your lead data protection authority. Well, there's a little bit of good news. It's actually 72 hours from the moment that you become aware of the breach. So if the breach occurs on a Friday night before a long weekend, and no one knows about it until Monday or Tuesday morning, that's okay because your 72 hours didn't start ticking at the time the breach happened. It starts when you become aware of it. But You do need to make sure that you create an incident as soon as possible to start tracking the breach and doing triage. You'll also want to have very good tested processes around reporting the breach, in particular managing the communications. And you should make sure you know the difference between reportable breaches and ones which are not.
16. For consent, I only need to change my terms and conditions to comply with GDPR.
Some businesses think that changing their terms and conditions is sufficient. Well, it's more than just changing your terms and conditions. Consent, if that's the legal basis that you've chosen for managing your personal data for a particular application, has to be separately managed from the regular terms and conditions. It has to be freely given, clear, transparent, and it has to be a positive opt-in. Consent has to be collected separately from the acceptance of terms and conditions. At the moment, many companies simply have a part of their T's and C's which contain the data protection consent. That's not going to work anymore. Additionally, consent has to be managed, allowing the logging so that you know when the consent was taken, who consented and what they consented to, as well as managing the withdrawal of consent which can occur at any subsequent time. Consent also has to be granular. That means you have to have separate consent for each different type of processing.
Our final myth for this afternoon: all profiling requires consent.
While it's true that many profiling activities can be based on consent, that's not the only basis for profiling. You can do profiling based on public interest, which is Article 6.1e, or legitimate interest, Article 6.1f. Where consent is absolutely required is when the profiling is being used to support automated decision-making, which has a significant or legal effect. And if such is the case, then data subjects can choose to opt out by withdrawing their consent, in which case the decision-making must be processed manually by a human and not by a machine. So that brings us to the end of this collection of myths. Now I'm delighted to hand over to Rob D'Souza, who will be talking about the Data Protection Bill. Thank you very much for your kind attention, and if there are any questions, we'll cover those at the end.
So thank you, Paul, for the introduction. So I'm going to talk about a couple of areas in relation to data protection. The first is some differences with the newly introduced UK Data Protection Bill, which is currently going through readings in Parliament, and talk about a specific area within the GDPR, which is Article 30. So to kick it off, then let's talk about the new UK Data Protection Bill. The purpose of this, obviously, when you look at Brexit looming in the coming months, is for the UK to have its own elements of what is termed data protection. And what the bill does encapsulate, I would say, is about 80 to 90% actually of the UK, of the GDPR, with some added idiosyncrasies for the UK. And with some changes in relation to what is classified as special data under the GDPR, and we'll come to that. So, some key areas that we should think about that hasn't really changed a great deal from where GDPR sits is the able to withdraw your consent if you so choose to, as you no longer wish your personal data to be used in a specific area. The right to be forgotten, which will be obviously built into UK national law, and the concept of explicit consent where special data is concerned. So there's two types of consent, as we're both aware. There's consent for personal data, and personal data is defined as name, address, email, phone number, bank account details, passport details. This is all considered personal data. Special data requires explicit consent, and what I mean by that is you are not permitted to process this type of data in any shape or form without the explicit consent of us data holders. What is special data? Well, special categories of data cover things like your medical records, if you're a member of a trade union, if you have any religious affiliations, your sexual orientation, any criminal convictions, so your criminal record, your racial or ethnic origin, your political opinion, your philosophical beliefs, excuse me, your genetic information, including biometric data, and any results of analysis or predictive analytics in regard to your behaviour and attitudes to your personal profiling. So it's quite onerous types of information that we're talking about. Now, the UK, under the change of this bill, has decided to slightly change what is defined as personal data within the UK bill, and has decided to bring in IP addresses, biometric data, and cookie data, which will be classified as personal data under the new bill, not special data. Why? Well, one of the reasons for this is the trying to bring the data protection bill in the UK in line with other acts which require the use of data, and this is especially where law enforcement is concerned. When looking at the Law Enforcement Directive, looking at the Investigatory Powers Act that was introduced at the end of 2016, these specific acts in the UK allow the use of this information in relation to criminal activity or in the event of terrorism. So what this is trying to do is beginning to encapsulate some of the law enforcement requirements within this new UK bill. You'll also see, if you ever take a chance to have a look at the bill, it's actually broken down into more sections, but equally, where law enforcement is concerned, it's broken down into two sections of its own, which covers UK national law enforcement and also the national security and defence services. So there's a clear difference between the two as to what information either is allowed to have access to in the event of criminality. So that's sort of some of the highlights within the legislation itself. As I say, it does adopt quite a large chunk of the GDPR with its own idiosyncrasies, and one of those idiosyncrasies is new criminal offences. And under the new bill, we've created 3 new criminal offences in relation to the misuse of data. One is internationally or recklessly re-identifying individuals. So if an individual has been anonymised for any reason or pseudonymised for any reason, if a company decides to intentionally or by mistake try and re-identify those individuals, that would be considered a criminal offence. If you decide to alter any records with any intent to prevent disclosure of or to a data subject, again, that will be a criminal offence. And unlawfully obtaining or disclosing data, also without the controller's consent, will be considered a criminal offence. And what I mean by lawfully obtaining data is things like scraping the internet or using data which you've not been authorised to use by the controller in the first place. So, some exemptions and some derogations. Then let's have a look at a couple of those. So there's the new excuse me the new concept of freedom of expression. So journalists actually will have some form of exemption derogation on the basis that they feel that it is in the interests of the public. There's a public interest in order for them to reveal personal details or personal data on the grounds of freedom of expression. We can see how there are two sides of a coin on that, and clearly it will be interesting to see how that plays out in the years to come. Scientific and historical research. So again, normally scientific and historical research, you are using normally anonymized types of information. However, this probably also would fall under the term of legitimate interest on the basis of carrying out research that would be deemed necessary. So again, consent would not be required on that basis. Finally, we come to the security services, and we come to the intelligence services and law enforcement in relation to using personal data for anti-doping. in order to try and catch drug cheats, suspected terrorists. Again, looking at financial services and looking at financial services records on the basis of the anticipation of things like money laundering and so on and so forth. So again, the bill goes a little further than GDPR because, as I said, it does involve a lot of law enforcement elements in there, and quite rightly so. It's important that the data is protected, but where criminality is concerned, equally it's important for our security service to be able to have access to that information. Finally, from an employee's perspective or an employer's perspective, they also benefit from an exemption when processing special categories of personal data, if they comply with specific conditions, and those conditions fall under, I think, Article 49.1 of the GDPR as it currently stands, and what that is around how you ensure that even though you're processing that information, you have the relevant safeguards that sit around it in order for you to process it safely. Okay, so enough about that bill. Let's have a little discussion around Article 30. So Article 30 is quite a onerous piece of information within the GDPR, and the purpose of Article 30 is that Article 30 is about the how your controllers and processors go about processing a data subject's personal data, and how they the activities that they use in order to make that process happen. So it's Article 30 is about the processing of the activities that's the responsibility of the controllers and the processors. So I've got a couple of mythbusters I expect around this, not as many as Paul had, but I've got one. One of them is around the data privacy officer has a legal obligation to maintain an data inventory and data map, and to carry out those exercises. Well, to be clear, that is not a legal obligation, not under the GDPR in any shape or form. It's an ask of the GDPR. It would be advisable that you do so, but there is no legal obligation for you to do so. In fact, the current Data Protection Act 1998 stipulates that you would have to register your processing activities with your supervisory authority, which in this case in the UK would be the ICO. You are no longer needing to do that under the GDPR. That has been removed. So you don't have to notify or register your processing activities in relation to the processing of personal data with the ICO. However, it is advisable that despite the fact you don't actually have to make such notifications anymore, that you do actually begin to maintain a record of all your organisation's processing activities internally. And why would you do that? Well, firstly, because it gives you a good handle as to where your data is, at what point it's being used, who is using it, why it is being used, what is being used for, when it no longer needs to be used. And secondly, it would be available to the supervisory authority upon request. That request could be in the form of an audit, that request could be in the form of a subject access request, that could be in the form of a complaint, that could be in the form of a data breach. So it's very important that despite the fact you don't have to register it, you have a legal obligation to produce these, that you do think very hard about maintaining a record of those processing activities. Again, talking about exemptions, Paul mentioned the 250 employee element. Yep, again, that sits in the same boat, but again, I would urge you not to take that as verbatim, and to manage those processes and keep records of those processes. So there are two elements where these processes are concerned. The controller has responsibilities for those processes, as do the processors have responsibility. They all have obligations to each other. The controllers are the gatekeepers, and therefore the obligations upon them are a bit more onerous, unlike the processors. And we're going to go through each very quickly. So what sort of records do you need to keep? Well, from a controller perspective, you need to keep the name and contact details of the controller who is dealing with the processing of that information. Where there is joint representation, you need to ensure that you clearly have the name and contact details of both. Why? Well, you need to ensure that every element of processing, when processing personal data, has a named controller against it, because they are, as I said, the gatekeeper of that data. You need to give a purpose of why you're doing that processing. So what are you doing it for? Is it a payroll? Do you do it on a regular basis? Is it a marketing campaign? Why are you doing the processing? And then a description of the categories of data subjects. So what sort of data subjects are you using here? Are you using 18 to 30, 55 to 60? What type of data subjects are you using, and the categories of personal data that you'll be using within those categories of data subjects. And what I mean by that is, are you using their birth details, their favourite soup, TV programs, their name and address, their postcode? It's important that that record is maintained. Equally, who's going to be receiving the information of that personal data? Who will you be disclosing it to? And by that I mean disclosing it to who's the recipient, the third parties, the country it's going to, international organisations that you're preparing this information for. You need to keep a record of actually who's going to be getting the information. And again, where applicable, is the data being transferred in any shape or form during that processing? Again, you must maintain a record of that. And looking at Article 49.1 in relation to safeguarding of that information, you have to identify that you've got a method and a process for the proper safeguards that you put in place that surround and wrap that data to ensure that when it's travelling from A to B, it does that safely. That safeguarding isn't just technical, but it also covers the business process around how that data and the methodology that you've devised to ensure the safety of the data when it's in transit. A more important element is how long are you going to keep it for? Once you've used the data, processed it, done what you needed, what are your time limits for removing that data and getting rid of it? And then the last point from a controller's perspective is the technical security measures that you put in place in order to secure that information on your infrastructure and the infrastructures that it's travelling to. So, what about the processors? Well, the processors, as I said, it's not as onerous as the controller. Again, you're going to require the name and contact details. Again, you need the sort of categories of processing. So, what type of process is being carried out by each controller? And again, where's the data going to? Where's it going? How's it travelling there? What safeguards have you put in place to ensure the safety of it moving? And what security measures are there to ensure the safety of that data when it leaves your location from your servers and it travels through the internet or through the communication network? How secure is that network that it's travelling down? So that's a very brief brief input, a brief update as to what Article 30 is and what it's about. I personally think it's a good article. It makes you think a lot about how you process information, why you're processing it, what you're going to do with it, and from a process perspective and policy, that you're keeping a record of this sort of stuff as well. So, just to touch on a new bit of legislation that's currently finding its way around the ether of the world of governments. There is a new piece of legislation that the UK are working in collaboration with our friends across the pond, the US, and it's a bit of a mouthful. It's called the Clarifying Lawful Overseas Use of Data Act, acronym CLOUD, which is quite an interesting act that's currently going through Parliament here in the UK and going through the federal system in the US. And there are three main areas as to why this act is important. The first is about how the US and the UK can access data stored in each other's country when there is a need to prosecute serious crime or to disrupt terrorism. So it's a method of us safely sharing information in the event of criminality. Now, as with every every law and act and how data flows. How you define the concept of criminality, and therefore what access rights you would have to someone's information is yet to be obviously discussed, but that is one of the main bullet points of this legislation. The second is to authorise the US Attorney General to enter into agreement with allies, and allies don't have to just be the UK, but it allows reciprocal compliance in order for the US and foreign court orders. So again, when the need comes to obtain that information from the UK, or for us to obtain information from the US, that there are measures in place where the proper court orders are put in place and granted before the use of that information is executed. And the third one is law enforcement in the UK and US will be empowered to investigate their citizens suspected of terrorism, serious crime, human trafficking, and sexual abuse of children, which I think is absolutely 100% important. So that's just a very quick insight into yet another bit of legislation that's focusing on protection, on the protection of our personal data and the use of that personal data in the event of criminality.